The Appeals Chamber notes that in its assessment of risks under Article 58(1)(b of the statute, the Pretorial Chamber relied on this legal standard. Indeed, the Pretorial Chamber correctly referred to the standard that the assessment under Article 58(1)(b of the statute concerns the possibility, not the inevitability, of a future occurrence. It then analyzed the material before it against this standard. Accordingly, the defense has failed to demonstrate that the Pretorial Chamber misapprehended the legal standard relevant to the assessment of risks under Article 58(1)(b of the statute. With regard to the Pretorial Chamber's assessment and weighing of evidence in assessing risks pursuant Article 58(1)(b, subparagraph 2 of the statute, the Appeals Chamber notes that the Pretorial Chamber made reference to 5 documents, including media articles, publications of non-governmental organizations, and a book which, in its view, indicated that Mr. Duterte's inclination to interfere with investigation against him. In relation to the first document, a media article, the Appeals Chamber finds that it was not unreasonable for the Pretorial Chamber to rely on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being directly involved in briefing individuals, it does not refer to statements of close, it does refer to statements of close associates, including one where individuals would have been told to remain loyal. In any event, the Appeals Chamber observes that Mr. Duterte's alleged involvement in briefing individuals is but one of the factors that the Pretorial Chamber took into account to support its conclusions on Mr. Duterte's inclination to interfere with investigations against him. In relation to the other 4 documents, a book, 2 publications of non-governmental organizations, and a press article, the Appeals Chamber recalls that there does not exist in the applicable law of this court any impediment to use of newspapers, articles, or other public or open sources for the purposes of assessing the requirement under Article 58(1) of the statute. Nor is there any requirement that such material be corroborated. Noting this, the Appeals Chamber considers that it is possible to discern how the Pretorial Chamber reached its conclusion on Mr. Duterte's alleged involvement in the threatening and taking of retaliatory actions against individuals opposed to him. In any event, the Appeals Chamber observes that this is only one of the factors that the Pretorial Chamber took into account to support its conclusion on Mr. Duterte's inclination to interfere with investigations against him, and more generally, on the risk of Mr. Duterte obstructing or endangering the investigations or the court proceedings. For these reasons, the Appeals Chamber considers that the defense has failed to demonstrate an error in the Pretrial Chamber's assessment and weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b, subparagraph 2 of the statute. In relation to the Pretrial Chamber's reliance on the notion of a network of supporters, the Appeals Chamber recalls that it has considered considered that it is sufficient for a chamber to establish that it is possible that a suspect had the necessary assets to abscond and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence.
Pwede siya tumakas.
The appeals chamber has also held that the existence of a supportive network and financial means may be
Parang
relevant
direksyon
to
ng
determining
ruling
whether there is a
i-deny
risk that a person
yung
may
interim
evade
release.
justice or interfere with the investigation, and that access to the international contacts could provide the means to enable a suspect to abscond,
Tumakas.
whether or not there was evidence that the suspect would actually utilize such contacts. In the impugned decision, in determining whether Mr. Duterte posed a flight risk under Article
Umiiyak na si
58
Kaufman.
1B, subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The appeals chamber considers that, contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte, and for which reason this supported its conclusion that the risk under Article 58 1B, subparagraph 1 of the statute was established. In the view of the appeals chamber, the manner in which the pretrial chamber undertook this assessment was case specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025. It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58 1B, subparagraph 1 of the statute. Further, under the first ground of appeal, the defense argues that the pretrial chamber's alleged reliance on irrelevant considerations led to errors of law and fact. Regarding the arguments on the assessment of evidence, and in particular, the defense's contention that a number of factors relied on by the pretrial chamber were irrelevant, the appeals chamber notes that when assessing the risk under Article 58 1B, subparagraph 1 of the statute, the pretrial chamber relied on several factors in support of its finding that such risks existed. It relied on a statement by Mr. Duterte, statements by others, Mr. Duterte's position as a former president of the Philippines, and his recent re-election as mayor of Davao City, as well as the matter of the gravity of the alleged crimes and concomitant sentence in case of conviction. The appeals chamber observes that the defense does not explain why, in its view, these factors were irrelevant to the pretrial chamber's assessment. Without more, the defense has failed to substantiate that the pretrial chamber's reasoning and assessment were unreasonable. In the same vein, the defense fails to demonstrate that the pretrial chamber's reliance on Mr. Duterte's re-election as mayor of Davao City in its assessment of the risks under Article 58 1B, subparagraph 3 of the statute was unreasonable. Moreover, with regard to the defense's contention that the pretrial chamber selectively cited facts and ignored others in the same items of evidence. The appeals chamber considers that the defense has failed to demonstrate how the fact that the pretrial chamber accorded weight to the statement from Mr. Duterte that it cited should result in the pretrial chambers ignoring or attaching no weight to other statements. Regarding gravity and concomitant sentences in case of conviction, it is recalled that the appeals chamber has consistently held that these factors are relevant considerations in assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, as these are factors that may increase an incentive of a person to abscond. In the present instance, the gravity of the alleged crimes and the possibility of a lengthy sentence was but one of the factors the pretrial chamber took into account in its assessment of risks under Article 58(1)(b), subparagraph 1 and 2 of the statute. And it looked at the specific allegations against Mr. Duterte. It follows that the defense has failed to demonstrate an error. Regarding the question of whether the pretrial chamber erred in fact by failing to give appropriate weight to relevant facts, specifically Mr.
Parang masakir
Duterte's
sa mga
short
arguments
condition
ni Kaufman.
and its mitigating effect on the risk factors set out in Article 58(1)(b) of the statute,
Umiiyak na si
as
Kaufman.
argued by the defense. The appeals chamber recalls that there is no provision in the court's legal texts that specifically provides for the interim or conditional release of a detained person on health grounds. Nevertheless, the appeals chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)(b) of the statute and may be a reason for a pretrial chamber to grant interim release with conditions. The appeals chamber considers that such a determination is necessarily case specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted the reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable.
Puro
For
defense
these
has failed.
reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected.
Rejected. So isa-isa binubugbog, minamasakir, pinapatay yung argumento ni Kaufman laban sa
Second
first
ground of
chamber.
appeal.
O second ground. Na
I will
first
now
ground,
turn to the
baksak.
second ground of appeal.
Second ground.
Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state warranties. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state warranties. The appeals chamber is of the view that the pretorial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58 1B of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warranties. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58 1B of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the appeals chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable.
Isa-isa binabaliktad, dinedemolish sa mga argumento nila Kaufman.
Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed proffered conditions in a situation such as the one at hand. It did so against the backdrop of having found that all three risks under Article 58 1B of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected. Third ground
Two grounds of appeal rejected na. Two grounds of appeals rejected na. Umiiyak na si Kaufman.
Regarding
Papalitan
the
na siya.
third ground of appeal,
Third ground
within
na,
which
third
the
ground.
defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, It gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable. The pretrial chamber found the existence of risks under Article 58(1)(b) of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release. The pretrial chamber then proceeded to analyze whether humanitarian grounds, as argued by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected.
Third ground na. Rejected pa
Finally,
rin.
the appeals chamber notes that the pretrial chamber reached its conclusions in relation to the risks enumerated in Article 58(1)(b) of the statute on the basis of a comprehensive assessment of the information before it. In the present case, having rejected the three grounds of appeal presented by the defense in the appeal brief, the appeals chambers unanimously confirms the impugned decision. This brings us to the end of the summary of the appeals chamber's judgment. The judgment will be notified to the parties and participants after the hearing. Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. Kuya Gula.
All rise. Rice now, rice. Only rice. Ano ba yan? Medyo hindi na walang introduction, hindi habang nagmo-monitor tayo, hindi na cover yung earlier part, yung mga may introduction pa. Pero ang nakuha natin, all three, di ba, na-reject ang, ayan na, umiiyak na si Kaufman, no? Kumukuha na ng tissue. Iyakan blues na yan, ha? Wala pa talaga yung actual decision, pero suffice it to say, ha, lahat ng argumento na ginamit ni Kaufman na para gibain yung mga yung mga grounds na ginamit ng pre-trial chamber 1 against led by Yula Mutuk ay isa-isa nilang giniba. May grounds on hindi siya tatakas. Sabi nila tatakas dahil maraming pera, malaki impluwensya. Sabi niya meron siya pera, meron siya network of support plus may political connection. So kumbaga kasama na nga dito yung network of support, yung pwede siya itatago ng mga OFW kung saan bansa man siya magtago. Pagkatapos yung sinasabi nila paulit-ulit yung meron political connection, yung the fact na naging mayor siya, naging former president siya, present mayor siya ng Davao, at yung nakasira pa sa kanya. Nakasira pa sa kanya yung sip-sip na sinabi ko na ba makakasira talaga sa kanya yung sip-sip na resolution ng Senado under Chis Escudero kung saan sinubukan pa sila mag-intervene. Sinubukan pa sila humirit sa ICC. So, yun, nagpapakita lang, malakas pa rin si Duterte. At delikado tumakas talaga dahil malakas pa rin siya. Sana hindi nila ginawa yun para ipakita nila humihina na si Duterte. Hindi na kaya gamitin yung power niya. Kasi 3 grounds ang mapipigil sa pagbigay ng interim release. Isa gagamitin niyo yung power niya para ulitin niya yung crimes na ginawa niya. Papatay niya ulit yung mga kalaban niya. Pangalawa, iharas niya yung mga kalaban niya. Pangatlo, tatakas siya. So lahat ito ng ground, inobjectan ng pre-trial chamber. Kaya ni-reject yung petition niya for interim release. Sinuportahan naman ng appeals chamber na ito nga nakita nyo, appeals chamber yan. Kumbaga sa atin, Court of Appeals yan. Kaya lang desisyon yan, final. Sabi nila hindi. May chance talaga na may connection pa yan, may power pa yan, gamitin niya yan para pumatay, gamitin niya yan para mangharas, gamitin niya yan para tumakas. Tapos yun, sabi rin, ginamit nila yung mga media reports, libro at video na kasama na dito yung sinasabi ni Sara. Susugurin natin. Let us gawan natin ng jailbreak para pakawalan si Duterte at iuwi siya sa Pilipinas. Kasama na rin dito yung mga media interview niya. Sabi ko na nga ba, bunganga ni Sara Duterte ang kalaban ng tatay niya. Kaya sabi nila na pati yun na sinasabi niya na yung na-vlog natin kanina, yung parati niya sinasabi, iuwi na namin yan sa Davao. Dahil mayor ng Davao yan. Dapat iserve niya yung term niya as mayor of Davao. Pati yun, nakasama pa rin. Bunganga ni Sara, bunganga ng tatay ang sumisira sa kanila. Yan, buti nga sa inyo. Karma, iyak-iyakan blues na naman. No wonder, ni isa sa mga Duterte hindi pumunta sa The Hague. Siguro natunugan na nila na sinabihan na sila ni Kaufman, mukhang problema talaga tayo. Talo na naman tayo. Ito si Kaufman, papalitan na talaga ito. Sayang yung 150 million a month dito. At paulit-ulit na sinabi, former mayor siya. Former president at Davao mayor. Kaya pwede pa rin niya gamitin yung power niya. Pero ang meron ilan sa inyo dito, binilang mga 20 times sinabi, the defense has failed to establish. Kumbaga, yung counter-argument, kumbaga, talo sa argumento. Wala palpak wala naman talaga argumento pwede ipresenta dahil ang lakas-lakas ng ebidensya ng mga prosecution. At hindi niya na ipakita na yung decision ng pre-trial chamber na unreasonable o ukol sa issue ng politika, flight risk at power. Pwede pa tumagbo talaga si Duterte at yun, sinabi ni Sara, iuwi namin yan sa Davao kung saan hindi nyo na yan pwede makuha. At sinabi rin dito, yung sa issue ng gravity, sabi nila, the fact na grabe talaga yung ginawa niya kriminalidad at malaking posibilidad. Ito, natawa talaga ako. Masayang-masaya ako dito nung narinig ko na masentensya siya dito. Dahil dito, na-increase yung flight risk. Ibig sabihin, more likely siya tumakas dahil alam niya, makukonvict siya. Alam niya, sigurado mismo si Duterte, makonvict siya. Gabundok ang ebidensya ng prosecution. 30,000 katao ba naman pinatay mo? So ito, maimplikasyon rin ito sa kaso ni Sara. Malakas ang kaso. Si Sara rin, susunod ka na. Lalabas na yung arrest warrant sa'yo next year. Dito rin daw, na-demonstrate daw ang defense to show na may error ang decision ng pre-trial chamber. At kwan rin nila, binasag rin nila yung grounds na health ng ni Duterte, declining health, na hindi daw ito automatically binibigay. At yung second ground naman, yung mga meron na identify na lugar kung saan dadalhin si Duterte, hindi nila na-prove na dito sa lugar na kung saan man third state, siguro hindi sa Pilipinas, yung merong bansa gusto pumayag na kupkupin siya, hindi nila na-prove na doon sa lugar na yun, hindi delikado tumakas si Duterte. So na-mitigate nila yung argumento na delikado pa rin siya tumakas. So na-establish pa rin nila yung three risk na dahilan na hindi pwede pagbigyan yung interim release ay andon pa rin. The defense failed to show error in its assessment on condition of release. Kahit yung third ground, humanitarian ground, hindi rin daw na-establish na dapat bigyan siya ng o kaawaan siya. Yung kahit daw may condition si Duterte pero hindi pa rin na-establish ni Kaufman na hindi delikado tatakas siya. Kasi pwede rin nagdadrama-drama lang siya. Ang hina niya. Yan. So wala. Hindi daw naipakita rin nila Kaufman na nagkamali on error on judgment, facts, and the law yung ruling ng pre-trial chamber. So in short, sa three grounds, bokya, sinushoot down nila yung three arguments ni Kaufman para baliktarin nila yung initial ruling ng pre-trial chamber under Judge Yulia Mutuk na dinideny yung interim release application ni Duterte. No wonder si Duterte hindi na nagpakita. Mga anak rin ni isa, walang pumunta roon. Andito lahat sa Pilipinas. Siguro natunugan na nila. Sabi na ni Kaufman, Bomalaps tayo mga bossing. Bomalaps tayo. Iyak na naman si Kaufman yan. At lalo na iiyak yung mga DDS na umaasa pa naman. Eto na! Pumalpak na kami sa EDSA 3. Pumalpak na kami sa rally sa 16, 17, 18. Pumalpak na kami sa junta. Pumalpak na kami sa people power. Eto na! At least mauwi na si Tatay Diggs. Wala pa rin. Bokya pa rin. Ayan naman. Puro naman kayo kapalpakan. Kawawa naman talaga kayo. Kaya binago na natin yung title natin kanina pa. Sure na talaga. Bokya na naman ito. So later on, we will come back to bring you naman yung assessment ng mga lawyers, ng mga ICC accredited lawyers. We will get back with that assessment. So eto, iyak na naman. No wonder, sa 10 lang. Ito lang sila. Ito lang sila, oh. Ito lang pumunta, oh. Sa 10 lang, mas marami pa mga reporter, eh. Mas marami pa mga reporter at cut out cardboard ng ni Duterte. Ito lang sila, oh. No wonder, eh. No wonder. O yan lang. Yan lang mga Pilipino nasa labas ng The Hague. Meron pa iba nasa gilid-gilid, pero mataas na yung 20. Mataas na yung 20. In short, nilangaw. Mahiya naman kayo, dala-dala pa kayo ng bandera ng Pilipinas, maka-China naman kayo. Ha? Meron pa kanina nag-prayer na akala mo nag-i-speech, eh. Kasi alam niya maraming media, o yan, CNBC, maraming media nag-cover. Ngayon, iyak kayo. Iyak time. It is crying time again, na Digong is gonna leave us. Wala na. Among the last na ito. Meron bang MR? Yung parang wala ata, tingnan natin, ha. Reconsideration doon sa ha. Pero parang meron ata, sa lack of jurisdiction. Baka meron naman. Kasi kung meron, yun na ang last. Kung meron. Appeal, ha? O yan, ha? So meron pa siguro appeal kasi andito si Harry Roque, kung meron pa yun, at least meron pa sila one more chance. Pero wala na, pawala na talaga yung chance nila. Paubos na talaga yung last chance nila. Ito sana, interim release, umaasa talaga sila. Kasi mas malabo makuha yung Mas malabo makuha mas malabo makuha yung lack of jurisdiction issue, Kumbaga dito sila mas may tsansa na makuha yung awa lang man ng ICC. Pero pati dito bokya pa rin sila. So kung malabo nila makuha yung interim release, mas lalo na yung reconsideration doon sa kine-question nila yung or hinihingi nila na i-dismiss na yung kaso dahil wala naman daw jurisdiction kasi hindi na tayo miyembro ng ICC. Yan. So yan, iyakin blues na naman. No Christmas in the Philippines for Duterte. Kaya no wonder hindi siya sumipot sa hearing. No wonder pinadala lang si Nicholas Kaufman na parang gusto na bury himself in the sand, gusto na lumubog sa lupa at umiiyak na, gusto na humagulgol. Ano kayang iboboljak na naman ito ni Duterte sa kulungan? Baka sabihin, wala ka talagang pakinabang, tuwat! Baka may pakinabang ka pa. Wala talaga. Kumbaga, ang sabi sa Ingles, when it rains, it pours. Kung minamalas ka talaga tuloy-tuloy, si Harry Roque, arestuhin na. Si Harry Roque, tinadyakan na ng the Netherlands this week. Muntik na maaresto. Kung natuloy siya sa Austria, arestuhin na sana siya. And then, hindi rin natuloy, walang nangyari sa People Power, yung 3-day rally, tinansel, ginawang 2 kasi walang nangyari. Pagkatapos this is the worst news sa mga Duterte. So kung wala na silang apela doon or denied na final na yung ruling na on jurisdiction, ibig sabihin ito na lang ang last chance na nila. So after this, tuloy-tuloy na yan ang trial. Ang masakit dyan, kung tuloy-tuloy ang trial, ibig sabihin, hahaba ay it will go the full course of 10 to 15 years. Kumbaga tuloy-tuloy ang proseso na 'yan. Wala nang hirit pa na mga may sakit, tuloy-tuloy na ang pagkulong ni Duterte diyan until mamatay siya or mabuhay ba siya in 80 years old na siya. So kung 10 years or 15 years ang kaso, dapat mabuhay siya up to 95 years old. At kung nasentensyahan siya, kasi sinabi ng korte ngayon, ang lakas ng kaso sa kanya, kaya delikado, tumakas siya. So kung matapos yung kaso in 95 years, buhay pa siya, nasentensya siya for 35 years, minus 15 years na nasa loob siya, ibig sabihin, kailangan mabuhay siya for 110 years para makauwi pa siya sa Pilipinas. Otherwise, he will go home in a body bag. Yan na. So, malaking implikasyon ito sa political run ni Sara Duterte sa 2028. Later on, iba-vlog natin ukol sa bagay na yan. So, for now, hanggang dito na muna tayo. Thank you very much, everyone, for watching. Thank you very much for joining me in this vlog. Thank you, Lord, for this good development. Wala pang exact ruling. Kasi ibang procedure sa korte nila. Ipopost na lang daw, ipapadala kina Duterte. Pero the fact na ni-reject yung tatlong argument, kumbaga ngayon presenta lang nila yung argument at ni-reject nila, ibig sabihin wala na. Goodbye na yung interim release. So buti naman. Thank you, Lord. So sige, hanggang dyan na lang muna tayo. Thank you very much, everyone, for watching. Thank you very much for joining me in this vlog, and see you in my next vlog.